All right. I think everything's good. Hey, Hamalio, Hoyet, Tistel, the Wito Notet. I said, hello, my friends. My name is Ethan Redigal Lawton, and I'm glad to be here with you today. Thanks for taking time out of your day, and I hope to share some helpful information and have question and answers towards the end. Continuing my introduction, my name's Ethan. My native name is Red Eagle, and my family name is Lawton. I'm originally from Alaska, lived in Arizona, San Diego, and been in Humboldt County area for over a decade now. I come from 4 different tribes, a quarter Inupiaq, which is under the Inuit umbrella, and we're located in northwestern Alaska. My family village is Kotzebue. And I'm also a quarter Sioux, part of the Oglala clan, and we're located in the Dakotas, north and south, and part of the 7 Council Fires. I'm also a quarter Navajo, part of the Bitterwater clan, and we're located in the Four Corners region, and we call ourselves Dene. Navajo is an Apache given name, meaning sheep stealer or sheep eater, and Dene means the people in our own language. I'm also a quarter Thona Atam and an enrolled member of the Thona Atam Nation. We're in southern Arizona, and we're formally called Papago. And again, Papago is an Apache given name, meaning cotton picker. And Thona Atam is people of the desert or desert dwellers in our own language. A bit more of my background. I have quite a bit of an experience in intercultural specialists, working with many different cultures, and have been working with tribes exclusively for about 12 years throughout the country, and kind of newer to planning. Been a planner for about 8 years now. I've worked professionally with over 50 tribes throughout the nation, and have personally been to over 100 reservations and have interacted with quite a few different tribes as well. As Bob mentioned, there's an overarching series that I've kind of spoken to. This graph kind of shows the previous topics, which I kind of forgot to update in number 6, but this is kind of going back to tribal consultation and kind of expressing more kind of the overlap between the consultation types. I'll primarily focus on AB 52 and SB 18. I'll lightly touch on section 106 and very lightly on executive order. So I do have a few disclaimers moving forward. When I talk about tribes, I'm not speaking on behalf of all the tribes. This is for educational purposes and is not intended for legal advice. I'm not by any means sharing any kind of politics, and this is definitely an oversimplification. Definitely review the code and go more in depth in your consultation. This purpose of this presentation is to compare the consultation types, AB 52, SB 18, section 106, and the executive order, and to provide you with a better understanding of both formal and informal consultation with tribes, including government to government. Question and answers will follow the presentation. Feel free to include them in the chat and we'll address them, and I'll have my email at the end if you wanted to email any questions in addition to that. So the outline of the presentation is introduction and disclaimers, which I covered, tribal consultation types. I'll cover the AB 52 process, SB 18 process, going over AB 52 and SB 18 side by side, and then the tribal consultation process overall. that will be helpful irregardless of what consultation type you do. And then I'll go over best practices and then Q&A. So consultation types. There are formal and informal. There's a lot of confusion around this because formal in some people's mind means it has weight and gravitas and has meaning, and informal is kind of off the cuff, and that's definitely not what it means. Formal means it's subject to actual criteria, whether that's section 106, AB 52, SB 18. The law outlines when, how, where, why consultation is supposed to happen. That's formal consultation. Anything outside of those would be informal consultation. And that's typically agreed upon both parties, and sometimes that's an MOU or an MOA, Memorandum of Understanding or Memorandum of Agreement. So if it's outside of those three requirements by law, it would be informal. And again, formal and informal doesn't mean it means less or doesn't carry enough weight. Both are equal in regards to importance. Both are equal in regards to outcome and meaning and significance. It's just formal has an outline per legal requirements, and informal is as agreed upon by both parties. So in addition to that, there's government to government consultation and staff to staff. Government to government includes section 106 and SB 18 as required by law. AB 52 is typically staff to staff, and legal, the CEQA has that expert to expert consultation. However, AB 52 often gets elevated to government to government. And so tribal council and the lead agency's government. But that's not always the case. Government to government includes tribal council members. Staff to staff includes typically the experts, which would be the TIPO, the Tribal Historic Preservation Officer, the cultural director or staff or department, the experts in that area. And in both of these examples, government to government and staff to staff, it can be delegated. So a designee can consult on behalf of either the government or the staff. So in this consultation, I really want to stress the level, especially when it comes to government. Tribes are viewed as equal to the federal government, equal to the state, equal to the county, equal to the city. And so we see that government to government is as equals. Tribes are not over or under. The government to government is two governments coming together for the purpose of consultation. So I wanted to stress that because sometimes tribes are viewed as kind of like a referral agency as opposed to a government to government. And this is built upon the foundation of treaties. As many people know and are familiar with, the federal government made treaties with tribes. And the federal government only makes treaties with other nations. And so it really reinforces that notion that tribes are nations. And treaties go to Congress and are approved and even ratified. And so treaties with tribes have gone through that process. Tribes have a sovereign status, and it's really contractual in regards to recognition of tribal sovereignty. And so consultation goes back to these foundational principles that tribes are their own nations, and even consultation between the federal government and tribes go back to even its concept. And tribes occupy a unique position in society. No other political entity possesses the same status as tribes and tribal members. An example of this would be the Supreme Court back in 1886 described Indian tribes as quasi-sovereign and semi-independent, possessing attributes over its members and territory, and was reinforced with another Supreme Court verdict in 1869 that said that tribes weren't even bound or limited to the Constitution, and even tribal members were not considered U.S. citizens until the American Citizens Act in 1924. And so again, tribes and tribal members possess a unique status in society, and again, all the more reason why consultation is there for tribes and the importance and significance of that tribal consultation. There are numerous other legal requirements and protections, Religious Freedom Act, the Resource Protection Act, the Preservation Act, the Graves Protection Act. All of these reinforce the importance of resources and the tribe's rights, and reinforce the consultation in identifying potential impacts and discussing potential mitigations. So again, that's part of the federal level. There's many at the state and local levels. And this is by no means exhaustive or comprehensive. These are just some examples of some federal laws that play into effect when it comes to consultation and resources. So in 2000, President Bill Clinton required all federal agencies to conduct consultation on a government-to-government basis. His quote I included here says, "The right of Indian tribes to self-govern, and that requires federal agencies to work to protect tribal trust resources and Indian tribal treaty and other rights." So again, the importance of government to government is seen throughout history and is even reinforced even more so in recent history. In 2009, President Barack Obama required federal agencies to engage in meaningful consultation. So I want to stress the difference between consultation and meaningful consultation. Many of the consultations are written in a way that's supposed to be meaningful, beneficial, productive, and work towards a certain thing, which I'll get more into in a moment. And that requirement is for federal agencies before taking any action. As we move down from federal to state, there are many different state regulations and different orders that come into effect in regards to tribal consultation. In 76, there was a Native American Heritage Commission that was kind of put together and has really played a role in regards to bridging the gap between tribes and state agencies. In 2004, SB 18 came into effect, and that affects local jurisdictions and their general plans or specific plans. And in 2011, Governor Brown signed an executive order, or Governor Brown Jr. signed an executive order creating the Office of Tribal Advisory and designated a tribal advisor. And that helped take another step into improving the relations between tribes and the state government, and in regards to consultation. In 2014 and implemented in 2015 was AB 52, and that added tribal cultural resources and a whole nother tribal consultation component to CEQA. which we'll get more into in a moment. But the Office of Tribal Advisor came by way of executive order and is codified in AB 880 and is part of Governor Gavin Newsom's administration. And this is part of the consultation between government and government, and plays a significant role in policies and projects and different things as the state moves forward. And the tribal advisor's charge is to serve as a direct link between the tribes of California and the governor and the governor's office, and to facilitate communication and consultation between tribe and state agencies. And then as legislation and regulations come up that affect tribes, the tribal advisor works with tribes and provides recommendation to the state in regards to that. I wanted to share a quick quote from Governor Brown, and it's: "The state and the tribes are better able to adopt and implement mutually beneficial policies when they cooperate and engage in meaningful consultation." So again, just reinforcing the importance and significance of meaningful consultations. And we see that trickle from federal level to state level. And now I'll go more in depth in the AB 52 process. So many of you are familiar with AB 52 and have experience in it, but I wanted to share a quick recap for those who maybe don't. AB 52 was approved in 2014, implemented 2015, and AB 52 is short for Assembly Bill 52. And it included, it stressed the component of tribal cultural resources and help include tribes in that process in identifying and addressing potential impacts to those tribal cultural resources. So this process goes like this. There is the California Native American tribe, different from federally recognized tribes. California Native American tribes include non-federally recognized tribes within state boundaries. The tribes request to be on agencies' permanent notification list. So tribes reach out to your agency, they reach out to the Native American Heritage Commission, and want to be added to the list for consultation. The second step is the agency decides to take on a project. And once that project is decided to be pursued or the application is deemed complete, within 14 days, the lead agency is to provide notice to the tribes on that contact list. And this includes a project description, the location, and a 30-day response for the tribe once it's received, not when it's sent, but when it's received. And so step 1, step 2, step 3, then we move on to step 4. Within 30 days, the tribe responds in writing back to the lead agency requesting consultation. And then within 30 days of that, receiving that response, the consultation is supposed to begin. And then from there on, there's no timelines. Consultation ends not by a certain time, but when both parties either agree on mitigations or in good faith and reasonable effort agree to disagree. And your administrative record should support either one of those conclusions. And then the final step is the release of the environmental document. So that's the AB 52 process. I'll go into the SB 18 process. Again, a refresher for some people and maybe new information for others. So SB 18 was approved in 2004 and effective 2005. SB 18 is short for Senate Bill 18, and it provides California Native American tribes, again, including federally and non-federally recognized tribes within the state of California, an opportunity to participate in local land use decision. So this involves general plans, special plans, open space designations. So the step in the process for SB 18 is that a local government decides to adopt or amend a general plan or specific plan. And then the local government sends a proposal information to the Native American Heritage Commission, and then the Native American Heritage Commission provides a contact list with the tribes to contact. And so that happens within 30 days. And then we see the next step that the local government must contact the tribes on that list and notifies them of an opportunity to consult. And this includes more information than AB 52. It includes a statement of purpose, description of the plan or amendment, and maps and a deadline date and a representative contact and a project proponent or applicant if applicable. And so that letter is sent to the tribes on that list, and it is typically confirmed by phone, email, fax, that it was received by tribes. Sometimes certified mail is an option, and is common as well. And so confirmation that the tribe has received it. Then we move into step 6. Within 90 days, the tribe responds. So again, we see different. AB 52 is 30 days, SB 18 is 90 days, indicating whether the tribe wants to consult or not on that general plan or specific plan adoption or amendment. Step 7 is consultation begins. And again, there's no time frame in regards to consultation itself. And then step 8, the local government continues the normal adoption amendment process. And then there's additional notifications when it comes to SB 18. And that's the 45 days prior to adoption. Local government sends notifications to, well, typically agencies, but it includes tribes. So when that 45-day notice goes out, be sure to include tribes in that notification. And then there's the 45-day prior to adoption comment period as well, which tribes are to be included in that in addition to the agency. So they can comment as an agency like government, tribal government, or they can comment as the public. And so there's those two options. In addition to that, 10 days prior to adoption, local government provides notice of hearing to tribes. So just like the public is notified 10 days prior to a hearing, at least 10 days prior, the tribe also needs to be included in that notification of public hearing. Then the public hearing takes action, and then SB 18 is concluded. So there are sometimes projects that include AB 52 and SB 18 together, and sometimes there's some confusion on when it's supposed to be one and not the other. So I'm going to briefly cover both processes side by side, just for clarity. So we have the AB 52 on one category, one column, and SB 18 on another column, and I have different categories. So we see the agency for SB 18 is state and local. For SB 18, it's local for cities and counties. For tribes, AB 52 is California Native American tribes. Again, that includes federally and non-federally recognized tribes. This is the same for both AB 52 and SB 18. AB 52 applies to any project that's subject to CEQA, and SB 18 is only for general plan, specific plan, and open space designations. So the initiating party differs in these two. AB 52, the tribe initiates it by wanting to be consulted and included on the list for consultation. And then SB 18, the local agency is the lead. The local government is the initiating party. They contact the Native American Heritage Commission. Both of these are proactive as opposed to reactive. And then moving on to additional categories, the California Native American tribe list for AB 52 is maintained by the lead agency, whereas SB 18 tribal contact list is maintained by the Native American Heritage Commission. Best practice is for the lead agency in AB 52 to contact the Native American Heritage Commission. However, by law, the lead agency is required to maintain a list of its own. And then this initiates 14 days after the complete application for AB 52, or when the decision is made to adopt or amend the general plan or specific plan. So that's the time frame. The response window is different. AB 52, the tribe has 30 days. SB 18, the tribe has 90 days. And so these are important timeframes to keep in mind as you work on an AB 52 project or general plan update. These, again, consultation has no time frame. It concludes when everything is addressed. So that's something to keep in mind. And often tribal consultation meetings are not just one meeting. And I'll unpack that, I think, in this next section. But noticing AB 52 has no required additional noticing. Best practice is to provide additional noticing. But SB 18 requires that 45-day and that 10-day notice for the tribes. Discussion areas. AB 52 discusses the project area and potential impacts and potential mitigations. SB 18 discusses the planning area, potential impacts, and potential alternatives or revisions. AB 52 is typically resources. SB 18 can include any tribal interests or concerns. Consultation type, AB 52, again, the way the law is written is staff to staff, experts to experts. However, sometimes it gets elevated to government to government. SB 18 is government to government. And then the purpose of these, as I mentioned before, AB 52 focuses on resources and SB 18 focuses on policy. The outcome for these consultation types, AB 52, the outcome is to lessen the impact or avoid the impact and to develop mitigations. SB 18 is to develop potential alternatives and or alternative revisions. So that's AB 52 and section or SB 18 compared side by side. And now I want to back up into the consultation process altogether. There are some similarities and some differences, but I think this process that I'm about to share with you is kind of the same all across the board, whether it's AB 52, section 106, SB 18, or even informal beyond those that we talked about. So what a consultation process looks like is something like this. It's kind of broken up into different parts. You have what I would call pre-consultation, and that's the initial meetings. And that then there's consultation part 1, the project presentation, part 2, project impacts, and part 3, the project mitigations. So pre-consultation includes figuring out what consultation looks like, who's going to be there, When is consultation going to take place? What is the format? Is it formal? Is it informal? Is it at the on the reservation? Is it at your agency's office? Is it virtual? Is it some at a third party location? Who's paying for what? If there's costs, all of this is figured out in the pre-consultation component. Once all that's figured out, then consultation begins. And so that's why I put part 1 in consultation. And this is more heavy on the lead agency side. The lead agency shares all the information about the project, what that project entails. That includes scope, project description, maps, potential timeline for that project. So the lead agency is sharing all of this information to the tribe. This is part 1. This could be a meeting. This could be a series of meetings. And then part 2 is more heavy on the tribal side. The tribe shares the potential impacts on resources. This could include sacred sites, historic properties, trust assets, any values or priorities that the tribe deems as important or of concern. And so the second part of consultation is the tribe sharing to the lead agency in the consultation process its concerns when it comes to these resources, impacts, and potential mitigations or alternatives or revisions. And so again, we see the shift from the lead agency in part 1 to the tribe in part 2. And then we get to part 3. And this is kind of the mutual kind of equal in regards to the consultation component. And that's developing, okay, we shared the project, we shared the potential impacts. Now what? How do we move forward together in a good way? And this involves mitigation, this involves alternatives, this involves revisions. And the discussion takes place here in the part 3 of the consultation. And hopefully it ends in agreement. And sometimes it ends in agree to disagree. And so the conclusion of consultation is to agree in to mitigate or avoid significant impacts on cultural resources, and or after good faith and after reasonable effort decide that mutual agreement cannot be reached. And again, your administrative records should support either one of these findings. So that's the way it should be maintained, and this should be kept in mind in regards to that. So I kind of put together this oversimplified graph. This light green, or this whole block, is consultation, and it's linear from left to right, from beginning to end. And this light green area is the lead agency or the firm or local government. This dark green is like the tribes. So as you move from beginning, the lead agency has the concept and produces the project description. Then the tribe shares the impacts, and together the mitigation is discussed and hopefully agreed upon. But ultimately, the lead agency has to make the determination based on substantial evidence. And so, again, this is an oversimplified example of the process and how both of these entities play a role in each of these steps in consultation. So as we wind down the presentation, begin to wind down the presentation, I wanted to leave some tribal consultation best practices, and then we'll get into some questions and answers. So first, best practice would be communication. Communication is so important, not only in life and in relationships and in work, but even with working with tribes. Early effort is always appreciated by tribes, even at the conceptual level. Even shooting an email saying, hey, we're thinking about this. What are some, some informal feedback in regards to that? And so the earlier, the better. And then maintaining consistent contact is good. There's a lot of turnover in agencies, a lot of turnover in tribes, and having consistent contact people or even multiple contact people, having people in the loop is important. And agency tribal liaisons are so vital. Every federal entity has a tribal liaison. Every state agency has a tribal liaison. If a state agency doesn't, they rely on the state office, tribal advisor, or National or Native American Heritage Commission. More and more, the private sectors are getting tribal liaisons. We have a tribal liaison, me at SHN, and that's to help foster relationships between the entity and tribes. Relationships are so important and can help with that consultation. In regards to meetings, consultations can be improved by having multiple venues, maybe having a meeting at the agency office in part 1 and having part 2 of the consultation meetings at the tribe's headquarters or offices, and then maybe part 3 at a third-party location, or maybe at the site itself. Virtual is becoming more common, especially through COVID. That definitely opened the doors and made that more as an option. Also, alternating facilitators. Not every consultation meeting needs to be run by you or your agency. Maybe a meeting could be run by the tribe, or maybe a third party, or maybe even have the meeting itself alternate facilitators during different times or topics. Participation in developing meeting agendas, having the tribe look and comment or amend the meeting agenda throughout the consultation process is a good practice. Having an open-ended, flexible agenda is also a good practice. Instead of having something concrete and 3 minutes that, 5 minutes this, 10 minutes this, having a flexible agenda that can be altered is the best practice. Decisions, getting to know the decision makers and on both sides, and tribal governments. Sometimes decisions by the tribe can be made at the department level. Sometimes decisions with the tribe need to be made at the tribal council level. So knowing when the tribal council meets, sometimes it's once a month, sometimes it's more, sometimes it's less. Sometimes a tribal decision needs to be made at the general council level with all the tribal members. Sometimes that happens once annually. So keeping that in mind in regards to your project and the consultation effort. Knowing limitations in resources. Everyone's stretched thin, everyone's overcommitted, everyone has a backlog, everyone's short on funds. So having that in mind in regards to the consultation effort is good, and keeping the other entity in mind is the best practice. So knowing ordinances, general plans, goals, and policies. Just as I mentioned, federal, state, there's also county and even city criteria to keep in mind when it comes to consultation, when it comes to discussing resources. Building creative agreements and protocols or policies, or MOUs, MOAs, standard operating procedures. When it comes to consulting with tribes is important. Sometimes the tribes have consultation policies or protocols, and sometimes your agency or government has one. So keeping that in mind and improving it or sharing it is also important. When it comes to consultations, conflict happens, and knowing how to move forward in a conflict is important. When it comes to conflict, I often get brought into conflicts to help move forward. I moved away from conflict resolution to conflict management because I'm not there to resolve the conflict. I'm there to manage it. It's up to the two parties involved to hopefully come up to either a resolution or how to move forward. So identify what is being said is good when it comes to conflict and learning more about true needs. So what I mean by that is sometimes a concern is expressed and the words don't truly reflect the intent of sharing that concern. So unpacking that takes time and is a process, and sometimes takes effort to uncover. Asking clarifying questions is always good. What do you mean by that? Or can you help me understand this better? Or are you saying this? And repeat it back to them. Asking clarifying questions when it comes to consultation can help avoid conflict or help clear up any potential misunderstanding. Brainstorming possible solutions together is huge and is uncommon. Either side wants to bring a solution or think their solution is best. Maybe having a brainstorming solution together is a way to help manage a conflict. And then discussing the solution effects. Every solution has the potential of causing another effect, either intentionally or unintentionally. So discussing the solution's potential effects is part of managing conflict. And then agree, implement, reevaluate, follow up, touching base, checking in, all of that's important. Most conflict happens from misunderstandings, and misunderstandings usually happen from lack of communication or miscommunication. And so improving communication is so important and plays a vital role in consultation and managing conflict. So that is a brief summary of some potential best practices to keep in mind in your consultation efforts. I wanted to leave some room and time for questions and answers. So this will be a great time for that. I've included my email and phone if you wanted to send one privately instead of publicly. And in case we didn't have time to address your question, comment, or concern, feel free to reach out to me. But with that, I'll hand it back over to Bob. And I didn't know if we wanted to do anything.
Sure, stay right there. So just looking at some of the chats and some of the questions, Tara had mentioned we had previously been advised that all communications, once formal consultation is initiated, should be done through certified mail. Can you provide any guidance regarding the accuracy of this guidance?
If you've been advised by the tribe, then that's great. If you've been advised by the state, that's a best practice. But in regards to meeting the legal minimum requirements, it's not specified. It's specified that it's sent, and it's specified that it should be received by the tribe. And so confirming that it was sent and received is best practice, as well as best for the administrative record, and certified mail is one way to do it, but not the only way.
You had mentioned earlier that staff changes, which happens in every agency and firm. And yeah, so making sure that the information has some follow-up, that make sure that the information gets sent to the right person or forwarded. And of course, we're always subject to some kind of virtual working arrangement, so it's always good to follow up. Another question from Amy, SB 18. When an applicant applies for a general plan amendment, does that process follow SB 18 as well? And I'm thinking maybe this has to do like with a map amendment as opposed to changing, or maybe it is changing property from residential to commercial, for instance.
Yes, it would be subject to SB 18. Like housing element, subject to SB 18. Minor, major amendment, subject to SB 18. So yes, it would.
Okay. Then also tribal general council meetings. At what point would a tribe or an agency determine that an issue needs to be discussed at the general council level?
That would be up to the tribe to determine their priorities and their level of importance in regards to discussion and or response. So typically that's done at the staff level. Usually when consultation letters are sent out, they're sent out to multiple people that include the chairperson, administrative staff to the council, the cultural director, if there is one, the TIPO, the Tribal Historic Preservation Officer, if they have a government affairs office or officer, typically they're included. So right off the bat, multiple people at the tribal level are included, and can evaluate from there once received and reviewed.
And I've heard you say in other places that this TIPO or someone else may not be the person who can answer that question. It may need to be elevated to the council or the general membership.
Correct. And again, having it sent to multiple people in multiple positions ensures that it gets received, as well as hopefully referred to the right channels for that evaluation, discussion, and determination.
We have another question regarding the main role of the State Historic Preservation Office, or SHPO, to provide consultation on projects that are subject to Section 106. Is that correct, or is it best practice to engage them for consultation outside of Section 106 project? And if so, what kind of projects should that occur?
Yeah, it's up to the lead agency to ensure that consultation happens, and it does the due diligence in that. In regards to Section 106, it'd be federal, and in that sense, it would be best practice for that lead agency to consult with the tribe directly, in addition to the SHPO, the State Historic Preservation Officer. So what's important is the due diligence and the administrative record in regards to deciding if the decision was made on substantial evidence. And so going above and beyond the minimum legal requirements is always best practice.
And SHPO sends out a referral to the tribe, so rather than be surprised, it's just as well to be contacting the tribes ahead of time so you know what kind of response they're going to have for SHPO.
Yes, in theory, there will be multiple consultations, one at the SHPO level, one at the lead agency level, one at the cultural investigation report level. It's not uncommon for it to take place multiple times in different ways, but ultimately the lead agency is responsible for that.
Okay, and then speaking on the topic of confidentiality, so you're meeting with the tribes you have some discussions. How do you determine what's confidential, what is available for the public to understand?
When it comes to AB 52, everything within the consultation itself is confidential. And then in regards to SB 18, consultation between government to government is also confidential. But beyond that, if you discuss resources, there are many federal and state laws of confidential in regards to the resources like significance and location and different things like that. There are additional protections around that. I would encourage due diligence in maintaining confidentiality, as well as when in doubt, asking the tribe if it's confidential, or if it's okay if it's not confidential is important. Many times records have a redacted version that can be released to the public, and or a cover sheet that says, hey, this is confidential. People with the right credentials can access it at this location or at this through this venue. Confidentiality is huge and is important, but also convoluted and has many aspects and components to it. I have a whole presentation on confidentiality. And so when it comes to documentations, all of that should be kept in mind, and is way too short to go fully in depth in that, other than what I mentioned about AB 52, SB 18, confidential requirements, as well as many state and federal confidential requirements.
So best practice is just to ask the tribe what is confidential. So even the applicant or the public wanting to know how the tribe is responding, that is, again, best defined what the tribe, consider it confidential unless the tribe says it's okay to. And that might be an action item at the end, is what is the what do you say after the meetings? What is generally publicly disclosable?
Yeah, there's definitely a high level of due diligence and effort when it comes to that, and that may take time and effort to reach that level.
Great. Well, that's the questions that were in the chat. I just want to mention Ethan has his contact information in the last slide there, and feel free, he's always very available to talk about issues that are coming up. And I just want to thank you very much for this presentation. It was very helpful. This will be on the YouTube site for the North Coast AEP APA. There are other recordings, and we have the other events that we'll be sending out on MailChimp, and feel free to share that with anyone you think might be interested. And with that, we'll see you next time.
Thank you so much.
Thank you. Thank you.
You.
Nice job, Ethan. Thank you. That was great.
Thank you.